Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Séverine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law.
Welcome, dear listener, and I'm reliably informed that this is podcast number 19 in our series of Unpacking Contract Law. And I am joined, as ever, in fact, physically, we are, for once, in the same room. But I am joined physically and spiritually and emotionally, I hope, by the lovely Professor Saintier. Now I've mangled the French. And the equally lovely Dr. Tim Dodsworth. And yours truly, Maggie Hemsworth. And here we are, number 19. We're going to discuss an international case of sovereign debt interest. So we're really reaching way above our normal punching weight, as it were. We're going to look at the case of Palladian, if I'm saying them right, and the Republic of Argentina. So hence the international aspect. And this is a case about sovereign debt finance. And so this is the Republic of Argentina borrowing and an arrangement, a sophisticated arrangement whereby they were supposed to be repaying this debt over a lengthy period of time. And you might say to yourself, well, why on earth are we discussing this? Because normally we're into contract law. And yes, it is contract law because there was a sophisticated contractual arrangement that set out the terms and obligations of the lenders, Palladian, and the Republic of Argentina, the borrower. So very quickly, some of the background before I throw it open to my colleagues to regale us with their views about this. This is sovereign debt restructuring. And the background, I suppose, is quite important, or it's certainly interesting. It's the national financial crisis that the Republic of Argentina found themselves in way back in 2001. So sovereign debt default was then apparently the largest then known in history of $80 billion US, which is a mind-boggling figure. Inflation was running at 40%. So if we think we're suffering currently in the UK with inflation, think about inflation at 40%. And 50% of the population were below the poverty line. And the debt GDP ratio, I'll just quickly explain that for those like me with limited economics. GDP is gross domestic product, a way of calculating the value of all the economic activity in the country at any given time. And the ratio between the debt and the GDP for that year was 130%. In other words, the state owed considerably more than the amount that they were producing in any given year. Hence the desperate need, I suppose, for refinance on a sovereign basis, that is the entire country. So the dispute, coming to the contractual part of the dispute centres around a relatively narrow part of a contractual document, which is talking about the way in which a table setting out the figures for GDP was to be recalculated because of a change in the way in which GDP was being calculated in the state from time to time. Now, the problem comes with any contractual document that is designed to span a long period of time. I think this is another classic instance of that because we have a possible span from 2005 right up to 2034. And so the document has a table, a chart or a method of calculating and recalculating gross domestic product figures. Now, you may be saying to yourself, well, why are we interested in any of this? And we're interested in this because Argentina's obligations to repay the lenders would only be triggered on 3 conditions, and they had to all be in place. The first one was the actual GDP for each reference year. That's linked to the table of years from 2005 to 2034, was greater than the base case GDP for the reference year. And that's the heart of this dispute, I think. The second condition was the actual real GDP growth was greater than the base year. So that's a percentage change requirement, I suppose. And the third one was the aggregate total amount of payments wouldn't exceed some particular payment cap. So there's 3 linked conditions, and I think when I read the case, I think that the centre of this is about that first condition as to whether the GDP for a particular repayment year had met or exceeded the figures in the chart. Now, the problem comes when you have a mechanism in the contract for rescaling, as it's called, or recalculating the chart. And that became necessary because the Republic of Argentina changed their, what they called the base GDP reference year, the base year. When they started the agreement, the base year, I think, was 1993. And they changed their reference GDP base year to 2004. So that all parties were agreed that in itself, that change would have necessitated an upscaling or recalculation, if you like, of the chart. So the dispute is as to how the method of recalculation and what that is doing to the figures on the chart, because we're all agreed that the repayment is not triggered until the GDP in any particular year in the Republic of Argentina has exceeded a figure for that particular year on that wretched chart. So once we start fiddling around, tinkering with the chart, it then becomes a problem, or at least there is the room for argument, as we have here, as to what's the correct method of recalculation. And I suppose that is the essence of it. The lender was saying, really, this is simple. You look at the wording on the document, and it's talking about, in essence, there's an adjustment and you need to have a formula, and you are using the base year 1993 as the denominator on that fraction, as it were. Those of us who are mathematically challenged probably, we've already lost this. Okay, but the denominator figure is the 1993 base figure. And the argument is, okay, what is the numerator? What is the figure that goes on the top part of the fraction, as it were? The lender is saying it is simple. If you read the language of the document itself, it is simply the 2004 new base year figure. So, in a sense, the fraction therefore looks like 2004 GDP over 1993 GDP. And so every figure on the chart has to be recalculated mathematically by multiplying the figure on the chart originally by this fraction. Argentina says, yes, well, we agree that it has to be rescaling, and we agree that it's a mathematical exercise involving a fraction, but you've got the numerator wrong. The denominator, that's the figure underneath, as it were, is the 1993 GDP figure. We're agreed about that. But the numerator, the top figure, is 2012. And you might say to yourself, where has 2012 come from as a figure? And the answer that Argentina had to this was, well, 2012 was the last year in which the Republic used the 1993 figures. So they were talking about the 2012 as the overlap year from changing, using a base figure built on 1993 years to one on 2004 years. Now, you can maybe stop and think, if you look at those fractions, where the motivation is coming from for that reasoning. Because if one assumes that gross domestic product, that is the economic activity in any state in any particular year, if we assume that that is going to grow naturally over time, you would expect, therefore, that the figure, if you like, in 2012 will be quite a bit more than the figure in 2004. How much more? Who knows? But just naturally incremental growth. If you say, for sake of argument, perhaps 1993 is base year, call it 1. 2004 might be 2. And so we can imagine in our mind's eye a fraction that looks like 2 over 1. In other words, multiplying the figures by doubling them on the chart for the 2004 over 1993 fraction. But on Argentina's case, if we're using 2012 as the numerator, we would expect maybe that to be 3 or 4 over 1, the base year 1993. And so you can see, therefore, that on Argentina's case, that chart, when it's rescaled, the figures are going to be quite a bit higher than the figures on the lender's calculation. So that's the sort of, I think, the simple idiot maths behind this as to the motivation. So the argument is really whether the contract has the natural meaning that the lender is putting forward, or does it have the meaning which Argentina is putting forward. And that's where we get finally to the bit of contract law. So my friends here are not dead. They are still with me, breathing and listening. So now it is your opportunity. Séverine, Tim, what do you think about the law? We finally got to some law.
And I think that's a key point. So if you are interested, dear listener, in more of the international finance part of this, you can pop across to our colleagues who have a podcast called Clauses and Controversies that we are on as well. We'll pop the link into the description of this if you'd like to find out more about the international finance side. But we're just going to focus on the contract side.
But it's American colleagues.
It is American colleagues, yes.
So they know a lot about finance, but perhaps not so much about English law. Is that what we're saying?
English contract law and vice versa for us.
So what do you think about the English contract law fighting to get out of the mathematical calculations?
Well, first of all, Maggie, I would like to say, it would have been so much easier had I spoken to you reading this. Dear listener, I love your expression, Maggie. This is a 300-paragraph long judgment by Mr. Justice Picken, and he did say right at the beginning that he was going to be brief. So, God forbid if he had not said he was going to be brief. So, thank you, Maggie. Is there anything you cannot do, Maggie? This was, I understood, in so much easier than I understood it when I was trying to read this. So, now that I've taken the mic, I better say something in contract. So, it's, dare I say, a non-controversial case on the law?
No new law, I would say. Would you say this?
Yeah, no new law. And
no law. But a way of seeing an illustration of the way in which English contract law wrestles with these sorts of problems.
Yes, but also I think what is interesting is to see the relevance of English contract law, because of course this was not, the reason why English law was relevant is because there was a jurisdiction clause saying that, the contract, even though entered by American hedge fund companies and the Republic of Argentina, it was subject to English law. So again, the relevance of English law. But for me,
so that's telling you something about the international reach of English law.
I know, of English contract law for sure, yes.
Why did they choose English law? Why didn't they choose the law of New York?
That is not explained, I suppose, because English law is seen as, certain, predictable, logical, and respecting of parties' autonomy and certainty of contract.
I think one of the key parts that Argentina was quite clear to put forward in their case was how they were trying to attract investors by saying this was stable, this was a solid calculation, they were not going to go back on their promises. And I think therefore picking an established jurisdiction is probably part of a way of enforcing that thinking or enforcing that message that they're trying to get across.
Yes.
So that might be part of it. What I found interesting, I think, was how much the judge opened up this idea of interpretation and going through various judgments in order to align them with the judgment. So with this, so one is, where does the factual matrix come in? At what point are we talking about ambiguity as well? And I think, Maggie, we had a brief conversation about this earlier on. Where does the idea of ambiguity come in? Does that come out of the factual matrix, or are we checking first whether there's any ambiguity and then checking whether there's a factual matrix?
I don't think I'd go as far as to talk about ambiguity. You don't need ambiguity to have well, I suppose, I don't know, I'm arguing with myself now. Rival interpretations. Does that mean the wording is ambiguous? I suppose it must mean that.
Well, we have that from Rainy Sky, don't
Yes.
we? Where they start talking about ambiguity.
Yeah.
And the idea of where they've used unambiguous language, the court shouldn't start interfering.
No.
So I guess the flip side of that is where they have used ambiguous language, well, then the court can start interfering. But does that ambiguous language come from purely the text, or does that come from the factual matrix?
There's a sort of what I would call patent ambiguity. In other words, on the face of the document, just reading it itself as a matter of the English language, it is ambiguous. That's what I thought that you were talking about. But there's also latent ambiguity.
Mm-hmm.
So the factual background might assist a party argue to the court that actually, when you read it, it makes literal sense. But when you take on board the factual matrix and the background, it's not that it doesn't make sense, but it opens up the possibility of there being a rival interpretation.
And I think that is what I quite liked, actually. So, as it happens, my eyes, fall on the relevant paragraph, which is a miracle. Because, Tim, when you asked the question, I thought, they did actually raise that question. So I'm going to quote at paragraph 137 that the ambiguity is not confined to linguistic ambiguity.
No.
And he said, so even where there is no strict linguistic ambiguity, which is the case here, the contract was not ambiguous, but where the disagreement come in is, and he says, where the meaning of the provision is nonetheless open to question.
Yeah.
So therefore, that is an interesting point.
Which is a more elegant way of describing what I think I was trying to say.
Yes.
That is patent ambiguity. Reading the English language, the sentence is not clear as to two or possibly more meanings, or latent ambiguity. It's only when you stop and look at the background that you stop and think, hang on, maybe there is another way of seeing it. And I think the strongest point, I don't know what you think about this, but I thought the strongest line that Argentina's counsel had on this was the background showed that when they were devising this wretched chart, everyone was working on the predicted growth for GDP of 3%. And mathematically, that chart does show that.
Yes.
So that would assist their argument, trying to give life or meaning to this upscaling formula expressed linguistically, that really what they were all trying to achieve was an upscaling of the figures as base years were being changed, but to preserve this idea of 3% projected growth. And I think that's probably their strongest argument.
I think for me, what is interesting is the fact that the consequences of the two possible interpretations had to be So I guess that's why the decision is so lengthy, because what Mr. Justice Picken does is really to try to do what he refers to, or what has been referred before as the iterative process. So if we have one possible interpretation, we need to test that interpretation on the commercial side, on the commercial consequences. So that's why the decision is so lengthy. But usually we see...
also the risk of appeal. Given the stakes are so high financially, that must mean that there is an increasing likelihood of an appeal.
Yeah.
And therefore any first instance judge has to really go through it with a fine tooth comb.
Yes, you're right.
Because of the prospects of the Court of Appeal going through it also with a fine tooth comb.
Yes, and we don't know yet whether that's...
No, so this might be appealed. And any first instance judge, I think, would have that in the back of his or her mind.
But also,
am I going to be appealed?
Yeah.
And I think that comes through here. The amount of times when he says, just to be clear, it is clearly aimed at knowing that it's going to go to the next stage.
Yeah. But also, and this is the interesting part for me, so this is not a normal commercial contract between two commercial parties. This is a contract between a sovereign state and a hedge fund. And perhaps one thing that is also therefore important to say, and that Mr. Justice Picken said at the beginning, that the disagreement was not done, so the dispute was not created because effectively Argentina was trying to get out of repaying the debt. So Maggie, you did make that clear, that it's in the Republic of Argentina, it was in their interest to repay, because the repayment had to be done based on the sustainability as well as the ability. It is in both parties' interest that this is repaid, because that means the Republic of Argentina.
But also, it's in any sovereign state's interest to show that any non-payment is fully lawful and legitimate, as it were. So in a contractual law setting is correct contractually. Yeah. Otherwise, who is going to lend to them ever again?
Exactly. But therefore, so for me, that was the interesting part, to see the impact of a contract in a much wider context, and therefore the importance of drafting, but also the importance of putting the contract in its setting, hence the importance of the iterative process, as Mr. Justice Picken puts it. So for me, that is an interesting point of the decision, because we can see the huge importance, and in spite of careful drafting, that those two possible interpretations were valid. So,
well, I think so. There's one interest. So the point Lord Clark brings up from Rainy Sky is that he says, well, this is one unitary exercise.
Yes.
And then he goes on later on, if I remember correctly, to split it into two parts. The first being, well, either there is no ambiguity, and therefore we're just giving it its plain meaning, and that's it, or there is ambiguity, and we don't look at how unreasonable the result might be. And the second is to say, well, or there is ambiguity and there's two different meanings, and we're then going to look at which is the most commercially sensible. Yeah. Now, the question that may come up with that is, well, are we looking at the end result under the circumstances, or are we looking at the commercial at the time the contract was made? Presumably, it's the reading at the time the contract was made, even if the end result then is going to be unreasonable under the circumstances that have happened.
But unreasonableness is probably too low a hurdle. It has to be something that looks nonsense.
More or less reasonable, right?
Well,
than the other one, because we've got two readings of the same clause, and we're saying which one is more likely, or in that case,
I'm not sure they put it quite like that. I think they're putting, if one of the two interpretations has no commercial sense, then that must be discarded. So it's not that they are both reasonable and one is more reasonable than the other. It is more that one of them is wholly nonsensical or lacking in commercial sense. So that's quite a high threshold. Do you see what I'm saying here?
Yes, but that's assuming that one is over the other. So I'm sure I know where. Yeah, so Lord Clark actually says, here we are, the court must give effect to that reading,
Yes.
however surprising or unreasonable the result might be. So that's if there's only one reading.
Okay.
But if there are two possible constructions, the court is entitled to reject the one which is unreasonable, and in a commercial context, the one which flouts business common sense.
Yes, okay, so he qualifies this idea of reasonable, unreasonable, something that flouts business commercial sense. That's sort of underlining that actually
but
that's...
But still in comparison to the other reading,
yes,
right?
But...
So they're always in a comparative
okay,
exercise.
That's for sure. But the one that flouts business commercial sense, that's stating it quite firmly, quite a strong sort of test in a sense.
Well,
but that's still not the outcome. That is still the clause as it was written at the time the contract was made.
Yes.
Well, when you talk about outcome, you have to look at the business consequences in order to judge whether one flouts business common sense. So it's not possible to understand the meaning of wording in a written contract without some regard to the consequences. But I suppose it's the difference between that, as we're talking about it, and unintended consequences. So if you know, a lack of judgment, you agree to something that in retrospect was daft, or you agree to something that actually wasn't in your best interests. I think the Supreme Court again and again are saying, so be it, tough luck in a sense, because of this freedom of contract. We don't rewrite contracts for parties.
Yes, there is a quote, and I can't find it, but it is the difference between something that is daft or that is commercially not very advisable and irrational.
Yes.
So I think that's where the court draws the line. So I think you two agree.
Say that. And that is then the end of this podcast. We have nothing more to say.
She's come here to insult us.
I was going to say, Séverine,
I think I have what you're talking about, Séverine. Somewhere in the judgment, they refer to a case called Sugarman and CJ Investments.
Yes.
And the judge there is saying, there is a fine line between something which is commercially unattractive or unreasonable and one that is nonsensical or irrational.
Yes.
And it's the latter where the court is going to say, hang on, because this is irrational and nonsensical, you cannot have meant this. Or even on an objective judgment, not asking you personally what you thought you were doing, standing back, and we assume that parties are rational, even if they're stupid, there is the sort of cutting line, as it were. So I have just a pedantic argument about, is it merely something that's unreasonable? And I think that Sugarman case is sort of indicating actually there is this fine line, and unreasonable on its own won't cut it, I think.
Yes, because what is interesting is therefore the balance. So, Tim, I think maybe what you were driving at is that, so yes, of course, the difficulty of the task of the court is that, and again, Mr. Justice Picken makes the point, so they have to look at it at the time the contract is made.
Yes.
And so hindsight cannot be used. But of course, and that's why I think you two agree, that ultimately, in order to see which interpretation is rational and makes commercial sense, the court needs to test what this interpretation will mean, of course, in the future. So that's the fine line between interpreting what the parties meant at the time the contract was made, but of course looking at it in the wider context of, but what it means in terms of consequences.
But I'm not sure in this particular case whether that argument was really centre stage, because
it was.
Well, I don't think it was. Either of the interpretations were, to use your language, entirely reasonable. There weren't, the Republic's case was not irrational in terms of its consequence. Neither was the lender's case irrational in terms of consequence.
Okay, so what I mean was center stage was the fine balance of actually testing whether which of the two made the most commercial sense. Yes, I agree with you, and that's why I said what I said earlier, that Argentina was not trying to pull one of the lenders, but there were serious different consequences as to...
No, all I'm saying is that question as to if there are two rival interpretations, the question, is one of them nonsensical and irrational? That question in this particular setting, I don't think was of any help at all, because both interpretations were not unreasonable, were not irrational, so that actually didn't get the judge anywhere in terms of an end result. Do you see what I mean?
Yeah.
So the question that he was then raising was which of these rival interpretations is closer to the text?
Yeah. So it was much more about, at the end of the day, it was much more about, is this a question of draftsman's blunder, error, and that the parties objectively, on an objective understanding of their intentions, did intend the Republic's calculation to be that they had agreed. And by error, if you like, in formulating a formula verbally, it had got mangled. And that's the sort of Chartbrook principle that sometimes people talk about, Chartbrook principle, which is sort of like correcting draftsman's mangling, not change the meaning, but to give sense to the meaning that has been expressed badly, as it were. But mostly, I don't know what you think about that. Most of the cases that I can think of that talk about Chartbrook are sort of syntax or the bracket in the wrong place. So investors' compensation, West Bromwich Building Society, the bracket was probably in the wrong place. Yes. Lord Hoffman would say, obviously, in the wrong place. Yes. Chartbrook itself resembles this one to my idiot eye, because it's a formula which is essentially mathematical, which the parties have expressed verbally. Yes. Now, I don't know about you, but I always think there is the seeds of some risk and a problem with that, because you're taking something which perhaps is more accurately expressed mathematically with figures and formula and whatever mathematicians use, and you're trying to cast that using words. And maybe there is more room for error.
Maybe also the legal draftsman people. Oh, you threw me a bone there, didn't you? I'm going to have to take that. So who knows all about... Yeah, this is not going to work this time. But anyway, we are very grateful to Newcastle Law School. And they are now offering a brand new LLM in emerging technologies and the law. Find out how law, economics, politics and society intersect in a digital world by visiting ncl.ac.uk to find out more. Thank you, Newcastle Law School, for sponsoring Unpacking Contract Law. Thank you, Séverine, for throwing me the bone.
I didn't
being too slow.
I didn't actually do it for that reason, but it does raise issue that,
well, tell the Newcastle people, if they could work in a bit of maths for lawyers, they would be doing a service, because I don't know what you think, but when I tend to see cases that are mathematical and have a formula expressed verbally, I think, oh crikey, if a lawyer's had anything to do with this could go badly. Or alternatively, I don't know what you think about, say, Chartbrook itself, Chartbrook Persimmon Homes. It looked to me as if the client had devised the formula and negotiated it with their opposite number, as it were, Chartbrook. So Persimmon, the house builder there, had devised the formula because they were the ones paying and they were kind of like calling the shots, I think, and then presented it to the landowner, Chartbrook, And maybe there was discussion about what it meant. Who knows? I don't really know. But then it was presented to the lawyers, who just sort of took it and ran with it, as it were. And maybe one needs to stop and think about formula that are expressed verbally in a contract to stop and think, hang on, does that mean what we think it means?
Yes.
Or could we express that in a different way?
Yeah, and maybe testing it.
Iteration.
That
would be
it. We go back to it. Yeah.
Which I think is maths or engineering. I'm sure I read that lawyers have hijacked this word iterative process. But actually, I think it comes from maths or engineering. Someone was going to have to check that out. Perhaps, dear listener, you've got a maths and engineering background. You would know this, but I think it is about repeating experimental processes, as it were. And iteration is to repeat something. And so lawyers have taken that word, having been led to do that by the Supreme Court, I think, in fairness, to now say that this is this testing of Séverine's rival interpretations. I think you were talking about that, weren't you?
Yes.
If you do, dear listener, have any more information on that, do contact us on unpacking.contract.law@gmail.com. We're always interested in your thoughts. Has that got us any further, though, so we've done the reasonable part, we've done ambiguity in the two senses, I think, that we've seen them, one being ambiguity in the language, the drafting blunder, the error, and the ambiguity in taking into account the factual matrix, and that then gives us the ambiguity, even though the language itself might not be ambiguous. It's the context within which it is ambiguous.
The context in which it is applied that gives rise to the ambiguity.
Well, your understanding of the language, having regard to the background, then creates in your mind uncertainty and doubt as to what it means. I suppose that's how I would think of it.
Well, that creates another possible plausible.
Yes, which is why I had that phrase, latent ambiguity.
Okay.
When you first read it, it doesn't look ambiguous. But when the more of the story you know, then the seeds of doubt are then planted in your mind. I think I would say
which
that.
arise not from the consequences and also not from the document, but from the factual matrix within which the whole thing happened.
Yes.
That was not a very good way of saying it.
Yeah.
Or what is the factual matrix that we're then looking at? Because I can imagine at least two different factual matrices.
Matrices, probably.
Yes. Two aspects of the factual matrix.
Well, is this projected 3% per annum growth? I think that's the point I was trying to make.
Yeah.
That is actually supportive of the Republic's argument, because when you look at the chart, actually it does match that idea.
Mm-hmm. So the ambiguity.
So you would assume, therefore, that any rescaling is going to stay true to that 3% projected, but maybe that's not what the end result was.
And that is therefore, so, what Mr. Justice Picken, for him, there were three elements of what is factually relevant, and the third one being what you've just referred to, that the intention, so this is a paragraph 154 and 155 for anyone who wants to go in and have a look. But the third one, which is the difficult one, that it is the intention behind the securities was that payment would only be made when the Argentine economy was growing at a sufficiently healthy rate, and that they would not be made if the Republic's economy was not growing. Yes. So that is
but this idea of sufficiently healthy is inherently vague and imprecise.
Absolutely.
So we are stuck with the language which the parties have used. Yeah. And as you said, Séverine, this is an international thing between a major sovereign state and lenders. Yeah. This is not something that's been jotted down on the back of an envelope in the pub.
No.
parties have expensive lawyers who have pored over the
Yes.
language, and that's going to make it even harder,
Yeah.
isn't it, to stray away from the language. And I don't know what you think, but I think that's why the Republic's case was a very hard one to make, because it involves putting in a fair bit of language into the wording, whereas the lender's case doesn't do that. It stays much more faithful to the wording. And when you stop and think that contracts can be done orally, can be done wholly in writing, and can be a hybrid of oral and writing, and that parties are very varied as to sophistication, this one is at the extreme end of the sophistication, isn't it? It's a sovereign state.
And large head.
Considerable borrowing. You would expect that parties have given very careful attention to every single word and every grammatical point, as it were, that is made in that document. So that, I think, makes it much harder for someone to then argue, well, that's not what was meant. It was really meaning, we've got to change that number. It's not 1993, it's 2012 here. And so the judge is saying, but 2012, where has that come from? There is no mention of it anywhere in the paperwork.
Yes, so I guess that is also what is therefore so interesting for me here is the fact that we are not dealing with. So usually when we look at contract interpretation, it's either one party over the other, and the court tends to look at it in a very adversarial position. But here it seems that maybe I am reading too much into it, being a good faith advocate.
French lawyer, you're trying to
Well,
say?
I was going to say, that took you all of, what was it, 40 minutes to say good faith. So
French.
Do
the French do things differently on this then, Séverine?
No, but on a serious point, the fact that that this is an unusual type of contract.
Well, it's unusual to us, but is it so unusual? Maybe it's not that unusual these days that sovereign debt finances structures using English contract law and a contract drafted by English lawyers. Is that unusual these days? I don't know. You'd have to ask an international lawyer, possibly.
How often is scared to be in the same room?
Well, Newcastle Law School might have a view about that as part of their LLM.
Absolutely. Not something I can help with, but they would.
Yeah, but for me, so maybe I haven't read enough, cases on debt restructuring.
Well, no, you're right. I think we don't see many reported. If that's what you're saying, Séverine,
that is what I am saying.
I'm being facetious. I agree entirely. We don't.
Good drafting, right? They could be just brilliant at drafting. The fact
Or-
we don't see cases is not an indication.
Or indeed that the venue for disputes is a private one,
Right,
and
yeah.
arbitration, for example, and we're
Yes.
just not seeing these
Yes.
things. That's all. Doesn't mean they're not there, like an iceberg.
Because these kind of sums.
Yes.
And I'm assuming states need that kind of. They need to get money from somewhere.
Well, clearly,
So-
that was, I think to me, that was absolutely clear. Argentina had defaulted. They therefore really, really needed that agreement. And so, of course, the fact that they defaulted made them, even more reliant on something. And therefore, but for me, that is an interesting aspect of how the contract law as a tool can be used in such a wide context. And so yes, maybe here I show my ignorance, but I think you two have made a point that just because we don't see those things very often,
It doesn't mean they're not there, but yes.
doesn't mean that they're not there. But for me, what is and I have found another paragraphs that I have highlighted, and it's paragraph 202 that also for me the context and the careful consideration by the judge. I know what you both have said, that it might be appealed, and so therefore Mr. Justice Picken needs to consider all the avenues, but also for me the interest that needs to be balanced, and at paragraph 202, and it is the third one that is important for me. In considering the economic position, it is important to have in mind that what Ms. Prevezer-Casey described as the balance of economic risks and rewards between the Republic and the holders of the securities. But
I'm not sure. Where does that get you? Because that's stating the bleeding obvious, isn't it? Given the structure of this, that the debt was only going to be repaid, as you said, Séverine, if the economy was of a sufficient state of health. There's the element of risk that the lender is taking. They've tried to nail down the description of that trigger point by the language of this.
Yeah, but for me that is important because it shows a different... Usually we portray, contracting parties are portrayed as at each other's throat, and yet here this is therefore...
Well, only when there's a dispute. At the time of the contract, they are, to the extent that they have a shared goal in mind, that is the performance of the contract, it would not be correct to say they're in dispute. Surely they are. No, they have a common interest at that point.
We portray contract law to be dealing with parties, the process is adversarial and the way...
Well, only when we see it, because remember, we're seeing cases, ergo, there's a dispute. But when a contract is formulated, there is no dispute, and the parties have, they have their own separate interests, commercial and otherwise, which may very well be in tension. I agree thus far, Séverine, but to the extent that they have nailed down their rights and obligations in the contract, that encapsulates their common interest, if you like.
I know, but the common interest is not... So the fact that here the common interest has to be taken into consideration, I obviously need to go back and read a lot more interpretation.
Well, it's the sort of background. When you look at this, the repayment, it's the idea of not being a simple debt. I think that's what we have difficulty with. Because if I borrow money from you, Tim, you would expect to be repaid that same money, regardless of my economic output or anything else going on in my life. That's the sort of simple debt credit arrangement between lender and borrower. This is more sophisticated than that. So I suppose, Séverine, if you're saying the risk is obviously much greater and enhanced in this sort of structure, then yes, I agree with you. I mean, a lender is always taking a risk that he or she will see nothing or only part of the repayment. But this one is risk writ large, as it were, because of the way in which it's structured. But where can we can't really go anywhere with that. That's simply a recognition of that. And you would assume perhaps that the other terms in the bargain reflect that element of risk. For all we know, they're getting some extra out of this than a simple interest being repaid, for example. It assists the lender to lend on this basis. Otherwise, they wouldn't have done so. Do you see what I'm trying to say? There's some commercial interest to them in taking this risk.
Yes.
So one assumes there are some advantages from that risk, which would not otherwise be had, is what I'm trying to say, in a simple, you've borrowed money, you repay the same amount sort of thing. It's enhanced in some aspect of the terms, which we've not really had to look at. But one would assume, you talked about them being hedge funds. That's not a charity, is it? No, let's be frank.
Clearly not.
So they are getting, if you like, their pound of flesh somewhere, and they have taken a view as to the likelihood of getting this pound, perhaps 2 pounds of flesh.
Yes.
or perhaps an arm and a leg.
Yes.
I mean, it's worth noting, I suppose, Argentina had actually paid $10 billion on this deal before the dispute broke.
Yeah, no, the as you said at the beginning, the sums are staggering.
Yeah. I have one interesting point that I've picked out that might be worth having a look at is where he draws a line between rectification and construction. And I mean, here we're going back to the case, what was it, FSHC or whatever, we've discussed here on the podcast already.
We have.
And where that line is drawn. At what point is the court actually still just construing? And at what point are we accepting there is simply a mistake?
Yeah.
And that mistake needs to be rectified. And actually, I can see his point here that the Republic's case was getting very close to really being a matter of mistake and rectification rather than construction. There was so much more that had just simply not been addressed at all in the document that we were getting fairly close to the point that really we should have gone down the mistake route, and the argument should have been, well, we just made a mistake in our drafting. This is not about construction anymore.
But you've got two sort of arguments then they would have had to have run. It was either unilateral mistake, in which case you are alleging that the lenders were aware that the Republic had signed something in the mistaken belief it meant X when actually it meant Y. That's going to be a difficult thing to prove.
I don't think that's the route they would have to go.
Well, that's one route.
Yeah.
The other one would be common mistake.
Yes.
And that's probably the one that you're thinking of.
Yes.
So they would have to have argued that both parties were under the understanding that the recalculation would be done in the way in which Argentina is now claiming. And prior to the contract, that was also a shared understanding of the lenders, and something passed between them objectively. So a stand-back judge, as it were, can see that there is evidence of this common understanding. And that's going to be difficult too, isn't it?
I don't think that's the biggest hurdle. I think the biggest hurdle would have to be to show that whatever was on paper was so far off that it had to be a mistake.
You just have to show that it does not reflect that which had been agreed. Yes, you don't have to have this so off idea. It's just that it does not reflect what had been agreed. So the court would have to decide first, what the heck does this mean? That would be base one. And Mr. Justice Picken has effectively done that in this case. And so the next step would be, okay, for rectification, now we're going to argue rectification, we would have to come up with evidence of documents and correspondence between the parties, which is showing very clearly, objectively, that the finding interpretation which Mr. Justice Picken has achieved is that which the parties thought at the time. That may be difficult on the correspondence to show that degree of unanimity, as it were, in terms of understanding.
Quite. So, I think you've failed both tests. In the test, the first stage of the test is it has to be clear that there was a mistake on the face of the document.
That's more about Chartbrook, I think. Chartbrook, this correcting interpretation or correcting interpretation, I can't quite remember the phrase that he's used.
It cannot be correcting interpretation, and Justice Picken makes the point that you cannot rectify by interpretation.
No.
Quite. So
There are different processes, I think, is all they're saying. Interpretation or construction is trying to work out what the heck this means.
Yes, what is the common understanding of the parties?
Of this text.
Well, objectively, stand back and look at this sophisticated document. Okay, accept him looking at the background facts insofar as that's helpful. What does this language mean? That's the interpretation stroke construction stage. Rectification, chart book principle is still part of interpretation or construction, because it's the court saying, looking at the language of this, it is clear that a mistake was made by the draftsman. You know, the bracket in the wrong place, the syntax being garbled. It is clear that a mistake was made. Plus, in addition, they would have to be able to show that the correction is itself clear.
Yes.
So there is no possibility of argument about what the nature of the correcting needs to be, because that would be, I don't know about a French court, but that would be a step too far for an English court, because it's shading into rewriting a bargain for parties, which English courts don't do. That's why I'm saying that the correction itself, what needs to be done, has to be absolutely clear, because then the court can, an English court at least, can sort of put their hands up and say, this is not us making your bargain. This is simply us making your bargain clear from the language that you have chosen to use. And where it is not clear from the language that you've chosen to use, then we correct it for you, but we're not making it for you. So some people might think this is a semantic argument, but there is a difference between correcting and making.
No, definitely.
I forget what you've asked now. What was that a question?
No, I asked the question. And yes.
So how long did it take you to bring mistake into this? It seems,
Touche.
Good. Yes.
We should explain, dear listener, that Dr. Tim has a particular interest in the law of mistake, and Professor Saintier has a particular interest in good faith.
And
I, of course, have no particular interest.
Oh, here we go! Not at all. Yes, and I think if you haven't picked that up, dear listener, by now, you need to go back and listen to more of our episodes. I think that brings us to the end, doesn't it?
We have exhausted this. We have wrung it for all we are worth, possibly.
Yes, and I am impressed by your notes. It is definitely nice to be in the same room.
I must admit, it really is. It's a very nice. Yes.
I hope, listener, that you've got. Well,
yes.
Also, I was just going to say that the listener maybe doesn't feel it was totally different, but has got something out of it, because we were actually physically within a couple of feet of one another, and we've not ended up in fisticuffs
yet. Thank you very much for listening. If you do have any comments, thoughts, ideas, or any cases you want us to discuss, then do contact us on unpacking.contract.law@gmail.com. Well, and thank you, of course, to our sponsor, Newcastle Law School. That is it. Goodbye.
Goodbye. Thank you very much.
Goodbye.